The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. Thanks again for watching and listening.
Hi, this is Andrew with Learn About Law. Today, we're going to be talking about what is a deposition in Iowa, who is allowed to take part in a deposition, what takes place during the deposition, and what can the deposition testimony be used for. We'll also discuss how to prepare for a deposition in the state of Iowa and some simple steps for giving deposition testimony in Iowa. So first, let's talk about what is a deposition. So in its most basic form, a deposition is an interview made under oath outside of the courtroom. The interview is on the record and carried out by the opposing attorney in order to gather information about the potential testimony of the opposing side's witnesses. There are generally two types of depositions, discovery depositions and trial depositions. The main difference between the two is that discovery depositions are a more open-ended process to determine what a witness knows and to get a feeling for how his or her testimony will play out in court. Trial depositions are a little more like what one can expect in a live courtroom, but they are not actually courtroom testimony. The attorney only has one chance to get answers from the witness, so he or she will usually run through a large number of pre-prepared questions depending on the case. So who is normally physically present during the deposition? Well, you can expect both parties in a case to be present, along with their lawyers and a court reporter who will record the deposition in its entirety. Again, the deposition will typically take place outside of the courtroom, usually at the office of one of the attorneys. So you're probably wondering what actually takes place during the deposition. The nature of the case, whether workers' comp, criminal, etc., will change the deposition somewhat, but generally all depositions follow a similar format. As mentioned before, during the deposition, an attorney from the opposite party of the witness will ask the witness a bunch of questions in order to better understand all the aspects of the witness's potential testimony. This process ultimately ensures that there are no big surprises during the trial. The attorney may ask very general to very specific questions about all aspects of the case. He or she may also ask the witness to identify documents relevant to the case, which will then be marked by the deposition reporter to be included in the deposition transcript. Often, the deposing attorney will ask about the accuracy of the documents and their connection to the case. So, can the questioning attorney ask any questions he or she wants? Well, the questioning attorney may ask any question relevant to the case. Since there is no judge present at a deposition, if the attorney party representing the person being deposed feels that the opposing attorney's line of questioning is erroneous or inappropriate, he or she may tell the witness not to answer. Sometimes this can lead to disputes between the two parties, which must be resolved, right? And these disputes will be resolved generally in one of three ways. So calling the judge's chambers, this means in real time the attorneys attempt to contact the judge in order to resolve the dispute. Certifying the question, right? So this means upon the refusal of the witness to answer a given question, the attorneys can place that question on hold for the judge to later decide the fate of the question. Then there's ending the deposition. Either party can terminate the deposition at any time, leaving the dispute to be resolved by the judge and then picked up at some point in the future. However, if the judge finds the reason for termination of the deposition disagreeable, he or she may hold the terminating party liable for the costs of stopping and starting the deposition. At the conclusion of the first round of questioning by the opposing attorney, the attorney representing the party being deposed is given the opportunity to rehabilitate the witness. This means the attorney will ask the witness a series of questions, like I talked about before, that cover topics from the adverse attorney's line of questionings. It basically serves as a chance to go over or clarify questions that were potentially detrimental to the case the witness supports. Lastly, then, the opposing attorney will have a final chance to question the witness and must only cover topics or questions asked by the witness's attorney, right? So it goes first, back, and then forward again. A deposition can be a long and exhaustive process for the witness, sometimes taking up to 3 hours, the normal limit for deposition. So why all the questions, and what can really the deposition be used for? Well, one big thing is information gathering, right? So first and foremost, the deposition is used to gather information. Before the two parties even meet for the oral portion of the deposition, written discovery usually takes place. This is requested often by both sides in order to get written testimony and any documents pertinent to the case. The information from the written discovery is then compared to the information gathered from the oral deposition and used to reveal any discrepancies or inconsistencies in the witness's story. This ultimately allows the attorney to have a much better understanding of the intricacies of the case and the evidence the other side possesses. Deposition testimony may also be used for impeaching of the witness during the trial. So here it's very important that the witness's deposition testimony and testimony during the trial match up if the witness is to avoid impeachment during the trial. If there are, let's say, inconsistencies between the written, oral, or the trial testimonies, the opposing attorney can submit the deposition transcript, putting into question the witness's credibility, essentially asking the question, which is a lie, the deposition testimony or your current testimony? The third use of deposition testimony is for preserving testimony of a witness. So what this means is basically sometimes if a witness will die before the trial, but after going through the deposition process, in this situation, the witness's deposition testimony can be entered as evidence and considered during the case. So lastly, we've got motions for summary judgment, right? So when appropriate, deposition testimony can be used to show that the facts or arguments presented in the case are undisputed by one side or the other, and typically one party or the other will request the motion for summary judgment. The side asking for the motion is going to be called the movant, and they are asking the judge to rule in their favor based on the facts and evidence presented from the deposition. This sometimes happens when the deposition reveals evidence and information that makes the presented case very similar to a case ruled on in a certain way in the past. In this situation, the motion for summary judgment may be awarded. Also, motion for dismissal, right? This may occur when the information gathered from the written and/or oral deposition clearly shows no ground for litigation and the case basically is just dismissed. So let's talk about some tips for preparing for a deposition in Iowa, okay? It can be scary for sure, but it's not really rocket science. And below are a few simple tips. So one, put yourself in the right state of mind before questioning, right? So again, no drugs or alcohol. That should be obvious, but be kind and respectful to the opposite party. Tell the truth. This is very important. You should tell the truth. Focus on answering only what was asked. Remember that you can take a break, right? If you get flustered or find yourself talking in endless circles, stop and compose yourself. Take time to think before answering the question. They are not there for you necessarily. It's really the other way around. If you don't know the answer, just say so. Do not guess. If you are the witness being deposed, the attorney for the side that the testimony supports will normally meet with you prior to the deposition, okay? The goal of this meeting is to make sure you reviewed any pertinent documents, are up to speed on any new information, and to make sure you have a clear understanding of the narrative and argument that the party your testimony is supporting is trying to make, okay? For more information on the deposition process and all of its elements, visit Learn About Law. Thank you for tuning in.
Hi, Kevin O'Flaherty again. Hope you enjoyed that presentation of Learn About Law presented by O'Flaherty Law. If you need some help, please give us a call, 563-503-6910, 563-503-6910. Again, we offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.